NFTs and how a technological trend redefined art ownership. In the past months, digital artwork sold through NFTs or non-fungible tokens, also referred to as crypto art, has become one of the most influential trends in the mainstream art world. This movement, which has certainly spurred by the pandemic and the necessity to buy online, recently peaked in terms of public attention and pricing in the auction of Beeple's Every Days, the First 5,000 Days by Christie in March 2021. The collage, consisting of 5,000 single images, fetched almost $70 million and was the auction house's first sale of a purely digital artwork backed by an NFT. Also, for the first time, payment for a lot was possible in the form of the cryptocurrency Ether. The description of Beeple's collage on the webpage of the online auction indicated that this work is unique. Seemingly enough, the 5,000 works included in Every Days are also uploaded on Beeple's website and can at any time be freely accessed by anyone with an internet connection. Against this background, the question arises, why are investors willing to pay incredible sums for a freely accessible work consisting of only digital images? And voices have been raised suggesting that it is not the artistic quality of the work that plays the decisive role in such sales. And recently, a curator at Harvard pointed out in an interview with the Harvard Gazette, it seems to me that this is about money and it's about ownership more than it is about a form of art in the spheres of which this curator has been trained to think about a work of art in its care. But how can value be created for a publicly available and infinitely multipliable asset? To understand the current market dynamic, the basic underlying tech of NFTs needs explaining. Moreover, when the quick rise in popularity and complex nature of NFTs, many legal issues remain unexplored and therefore provide for insecurity of market participants. This will lay the groundwork for future debates on this emerging phenomenon and invite practitioners and academics to become familiar with the remaining tech and legal challenges of NFTs. What are NFTs? These are blockchain-based tokens, i.e. digital transferable assets which represent an underlying value. They differ significantly from currency tokens, which can be used for cryptos such as Bitcoin, since NFTs are unique, hence non-fungible, and cannot be divided, merged, or replicated. Conversely, fungible tokens used for cryptocurrencies are interchangeable, like dollar bills. Bitcoins can be exchanged one for another, and as long as the number of Bitcoins corresponds, the transfers will still be in the same financial and proprietary situation as before. NFTs, on the other hand, are individual and distinguishable crypto items that represent other assets, not only digital artworks, but for example, also tangible items such as automobiles or real estate, perpetually through their incorporation into a blockchain. NFTs fulfill the function of entries into a digital public register, which is constituted by the blockchain, allowing for an immutable record of transfers. In this constellation, NFTs represent their underlying asset and include the necessary information to unambiguously identify the holder of the corresponding rights in a transparent manner and for everyone to see. Hence, when trading a certificate of ownership, example of a digital baseball card with a unique value, one can make sure that the transaction is recorded on a public ledger. Moreover, due to the structure of NFT-compatible blockchains, metadata can be added to the tokens. This may include legal responsibilities, a bit of text describing the underlying asset, or even a small image. The artwork itself, however, is usually not stored on the blockchain, but off-chain, since on-chain storage capacities are limited, and including information of a digital file can cause exhaustive costs during the NFT creation process. Interestingly enough, the NFT tech also allows for establishing conditions for resale of art on the secondary market by means of smart contracts. Such self-execution contracts, following a series of automated if-then rules, artists can declare themselves beneficiaries of any future sale, writing the percentage they consider appropriate in the contract without having to rely on legal enforcement for asserting their claims. What accounts for the central feature for NFT success in digital art sales is the aspect of scarcity. They attribute to each work, which in the eyes of an investor is crucial. Principle, a digital artwork being represented in a digital file is in theory infinitely reproducible through copying or sharing. NFTs, on the other hand, provide each registered artwork with an individual identity, thereby creating verifiable originals can be traded as parts of a limited edition, authorized by the artists themselves. To refer again to the example of everydays, there will always be only one everyday NFT, not reproducible nor divisible. That represents Beeple's collage that was sold as the first purely digital artwork at Christie's. As a consequence to limiting the supply, the competition among potential buyers to own an authorized work of the artist rises. A similar phenomenon can be absorbed in the physical world. Although everyone can photograph a work of Claude Monet or Keith Haring in the museum or buy posters, people will still consider it worth paying extraordinarily high sums of money or cryptos in order to own such a masterpiece as an original. What are the legal implications of NFT art sales? A sales agreement between parties on NFT art does not only need to refer to the digital artwork, but also to the asset-backed token which represents ownership. It is therefore of utmost importance to take a look at the pertinent set of rules that may apply to a transfer of ownership of NFT art. Securities. The sale of tokens is not generally unregulated. Rather, authorities in the US and EU have increasingly addressed the sale of blockchain-based tokens through regulatory guidelines, which highlight the relevance of emerging tech with regards to financial market regulations. In fact, some token types have been recognized as financial instruments, therefore being subject to security laws. This is typically the case for tokens issued in so-called ICOs, initial coin offerings, that can be characterized by a strong and reasonable investment component, such as the prospect of financial profits comparable to dividends from shares. In the US, this legal classification was initially established through the SEC report on Decentralized Autonomous Organization (DAO) token sale, published in 2017. Proposals on how to treat the funding of organizations through the sales of tokens are also being discussed in the EU at national and supranational level. However, it should be noticed that there is not yet a uniform approach across Europe, with differences in terms of terminology and legal classification. While the investment aspect of NFTs representing digital artworks cannot be denied, particularly in correlation to the current development on cryptocurrency markets, NFTs representing digital artworks as a unique trophy or part of a limited edition by a single artist do not exhibit the necessary parallels with securities that would require the application of security law. Contrary to securities, NFTs establish their value through uniqueness, as is implied by their name. One does not equal the other. They are not transferred by a certain number or amount, but one by one. In acknowledging precisely the fact that there is only one NFT that represents the whole underlying asset, not just shares of it. And to summarize, NFTs representing a single artwork or work of a limited edition intellectual property rights. NFTs, as opposed to the underlying artwork, do not generally qualify for IP protection, whereas the underlying asset of digital art may call for the protection under US and EU copyright law. The process of creating an NFT itself does not exhibit the necessary level of creativity. And according to a recent publication, at least a modicum of creativity is required under US copyright law, referring to a minimal degree of creativity and independent creation that is necessary for the works to be protected. The NFT creation process, referred to as minting, lacks the necessary creativity and innovation, since it allows a predetermined format of coding to enter information into a blockchain. In spite of NFTs not qualifying themselves for copyright protection, they might still be able to strengthen authors' rights with regard to the underlying asset. Such has been suggested by NFT enthusiasts and authors' rights associations. Indeed, through their insertion into the blockchain, NFTs allow for a traceable holder history, thereby leaving no doubt as to the original issuer who would generally correspond to the author of the artwork. Moreover, as mentioned above, the structure of smart contracts allows for authors to install a predetermined resale royalty that is automatically applied to any subsequent sale on the secondary market, thereby putting the suite to direct execution. Besides, as a consequence to the division into the copyrightable artwork and the NFT, artists may more readily renounce to the available financially exploitable copyright protection in view of the participation in any future sale proceeds secured through smart contracts. Accordingly, many digital artists have put their creative works under Creative Commons licenses, thereby allowing for free use of their works and derivative amendments of the original. This is not to say that NFTs have purely positive effects on author rights. Cases of copyright infringements and copy fraud have been reported, which exploit the fact that an NFT can be practically linked to any off-chain asset or data set without the necessity to prove ownership or author rights regarding the underlying object. In this context, one has to bear in mind that the reliable information inherent to an NFT extends only to what is on the blockchain. Example, the chain of transactions and the metadata which links the NFT to a concise asset. Whether this asset is an original and whether the issuer of the token holds the respective copyrights can be automatically assumed simply because the work is backed by an NFT. Also, it would be a mistake to assume that by the purchase of an NFT, corresponding copyrights are automatically transferred. Alike to the situation where a tangible artwork is purchased, the scope of copyrights that are passed along with NFTs is also subject to the concrete terms of the contract. In absence of any further clarification, it cannot be assumed that all of the author rights are intended to be transferred to the purchaser, but rather only the rights related to personal use and display. In the case of Every Days, the condition of sale explicitly states that there is no guarantee that you will gain any copyright or other reproduction rights to this lot. Instead, the buyer had to acknowledge that ownership of an NFT carries no rights, expressed or implied, other than the property rights for the lot. Transfer of ownership, which leads to the final point under examination, under which provisions can property of an NFT be transferred. One would assume that the technical specifics of artwork-related NFTs require for tailored regulatory guidelines. However, in this regard, the absence of token-specific regulation is striking. In particular, against the background of the current boom of NFT trades, the UK Jurisdiction Task Force is one of the few state authorities that issued a legal statement precisely addressing the issue of ownership of NFTs. The prevalent concept of ownership in common and civil law jurisdictions is premised on two requirements: control and exclusion. Ownership grants the right holder the possibility to do with an item as one pleases and exclude the others. With regard to blockchain-based NFTs, both requirements can be considered satisfied. The conditions of control over the asset and the exclusivity are met by restricting access to a private key, which allows the holder of the asset to control it to the exclusion of others. However, when it comes to traditional classification of ownership, legal systems seem regularly overstrained in view of the digital format of NFTs. Common law traditionally distinguishes between two specific types of property, namely things in possession, movables, and things in action, right to sue. In the UK legal statement on crypto assets, the conclusion is reached that crypto assets do not fit in the conventional classification, which should, however, not impede them to be treated in principle as property. Analogies could, in this regard, provide a feasible solution. The UK and other jurisdictions may profit in this regard from the ability of the common law to stretch to traditional definitions and concepts to adapt to new business practices, against the background of judges applying and adapting existing principles by analogy. Whether civil jurisdictions will allow for a similar flexible approach to the emerging tech of NFTs remains to be seen. According to the condition of sale employed by Christie's in the case of Every Days, the non-fungible token encrypted with an artist's signature that confers to the holder of the NFT an ownership right to the corresponding lot which is a work of digital art. Accordingly, the title for the digital art is passed via NFT, which indicates a holistic approach whereby the ownership of the digital artwork follows the ownership of the NFT. Whether a singular transfer of title encompassing both aspects, the asset and the token, is sufficient, comparable to transferable title, concurring instrument cannot be definitely established at this point, as such a transfer of title has not been legally recognized yet by any of the examined jurisdictions. In conclusion, digital artworks draw large parts of their attractiveness for collectors and investors from their connection with NFTs. Through this composition, a quantitative limit is achieved for an art genre that is generally publicly available and infinitely reproducible. Given the novelty of NFT tech, there remains great insecurity as to its legal implications, in particular with regard to the transfer of ownership or via NFTs. Essential questions such as whether the title of NFT also provides a valid title to ownership of the underlying asset, or whether both may be transferred independently, require clear regulatory instructions if the current trend towards digitization of assets is expected to be kept alive. And since NFTs can be used for a vast array of assets, the tax potential is enormous, especially in the art market that is plagued by concerns of authenticity and provenance. Linking artwork to an NFT could constitute a transparent and secure solution that would facilitate trade and decrease transaction costs essentially. Against this background, it is of utmost urgency to initiate an academic discussion on this topic and bridge the gap between static law and technical advancements.